Singapore's apex court has found Workers' Party town councillors grossly negligent in their payments process to a managing agent overseeing Aljunied-Hougang Town Council. It said it cannot see how the conduct of Workers' Party leaders Sylvia and Pritam Singh, as well as former chief Low Thia Khiang, can be said to have been done in good faith. Now, the latest development comes in a saga centred on the misuse of $33 million in town council funds. The Workers' Party personalities had appealed against an earlier judgment that found them liable for the misuse of the money.
At the centre of this portion of judgment, the issue of verifying payments for services. Ms. Lim, Mr. Lau and Mr. Singh, who were required to sign payment vouchers, were presented with cheques by people who had a conflict of interest. The owners of the managing agent, FMSS, Ms. Hao Wing Fan and the late Danny Low, were also WP supporters and town council employees. The court noted that the three town councillors simply tallied the amounts with the relevant invoices. It said there appeared to be no actual certification or verification of work done. It described the process of having the leaders sign off on the cheques as a woefully inadequate safeguard because it involved people with a conflict of interest. It cited Ms. Lim's earlier testimony that it would not be practical for her to personally verify that every item of work had been completed before signing off on the cheques. The court raised the possibility of AHTC employing a team of inspectors as a safeguard against conflict of interest, saying such an expectation cannot be impracticable or onerous. The court said it's unable to see how such gross negligence can be said to have been done in good faith, emphasizing the importance of oversight when public funds are used. It later said this means Section 52 of the Town Council's Act, which exempts individuals from personal liability if they had acted in good faith, would not apply. Beyond mere negligence, the court said the town councillors were aware of Ms. Howe's and Mr. Low's conflict of interest, but did not address it. It said the town councillors believed there was a risk of improper payments to FMSS, which is why they required cheques to be signed by them. Yet, AHTC did not have the processes in place to independently and objectively assess work that had been done. Despite the risk, the state of affairs was allowed to persist for at least 3 years, during which $23 million had been disbursed. It said such neglect was potentially grave. It said that while the town councillors trusted FMSS to carry out works properly, it does not address the need for a system to verify payments to the managing agent. Compounding matters were the conflicts of interest that all parties were aware of. It called this a paradigm example of poor financial governance and a breach of the duty of care. The court said that since town councillors are not exempt from personal liability, the quantum of damages, if any, will be dealt with at a later time.
So what exactly does good faith mean? In this instance, the case summary states it minimally means no deceit or intentional wrongdoing, as well as no intention to gain an improper advantage or of any improper purpose. In addition, the Dispute Act had to be done honestly for proper purposes and with a basic degree of competence and diligence. In this case, the Court of Appeal found that the WP town councillors had acted in good faith in appointing the managing agent, FMSS, to Aljunied-Hougang Town Council. They had awarded the company the contract without first putting up a tender for managing agent services. In this decision, the Apex Court overturned points in an earlier judgment, which had ruled that the leaders breached fiduciary duties.
When the Workers' Party wrested control of Aljunied GRC from the PAP in 2011, WP chief at the time, Low Thia Khiang, believed that then managing agent of the town council, CPG Facilities Management, would not be committed to the role. The appeals court pointed out that there is an unmistakable political overtone that coloured the way matters were seen by the town councillors, who believed that major managing agents preferred to work with PAP-led town councils. It said the earlier judge failed to pay sufficient attention to a May 2011 email which showed the town councillors believed a crisis could happen because they thought that CPG might go slow if it continued serving the town council. The WP leaders were concerned that they would have to take over at short notice to prevent residents from suffering poor service. The court said the situation was inevitably politicised to a degree, since the performance of a town council is seen to reflect the performance of elected politicians. It disagreed with the earlier judge's suggestion that CPG could be sued if it proved unwilling to work, calling the prospect unrealistic, both from the perspective of good faith and when considering it was a new political team taking over from a GRC previously held by the PAP for the first time. Evidence also shows that it may have been difficult to find a willing service provider given the small number of vendors and the town councillors' perception that existing service providers were aligned with the ruling party. It said the appointment of FMSS was an interim one-year measure, with no indication that there was a plan for the company to cement its position for the longer term. The apex court concluded that the town councillors did act in good faith by waiving a tender for managing agent services.
Here's a look back at what led up to this ruling after the case came to light. In 2015, the Auditor-General's office flagged 13 issues in AHTC's accounts following an audit and launched a probe. In 2016, KPMG found improper payments of $33 million to FMSS. It also found that shareholders held key town council positions, meaning that they could approve payments to themselves. A year later, AHTC engaged an independent panel to sue the town councillors. That was for breaching fiduciary duties. Pasir Ris Punggol Town Council filed a similar suit as the Punggol East Ward was briefly under the Workers' Party. Then in 2018, a 17-day trial started, with cross-examinations digging into reasons why the tender was waived, if the MPs were transparent about the managing agent's dual roles, and if they had followed due processes in approving certain payments to FMSS. Then in 2019, the court ruled that Mr. Low Thia Khiang and Ms. Sylvia Lim breached fiduciary duties, while Mr. Pritam Singh breached his duty of skill and care. The judge said that Ms. Lim and Mr. Low had misled town councillors into believing that the appointment had been done urgently. Mr. Singh was found to be liable to a lesser degree, since he wasn't involved in crucial email exchanges that were pertinent to the case. The Workers' Party MPs appealed, and in a one-day appeal hearing last year, they argued that they weren't fiduciaries. Instead, they owed statutory duties, which entitles them to immunity under the law if they acted in good faith. Now, today's apex court judgment largely overturned the earlier ruling. It found that the Workers' Party town councillors do not owe fiduciary or equitable duties, but were negligent, mostly in processing payments.
The National Development Ministry notes with concern that the AHTC town councillors involved, including WP Chair Sylvia Lim, did not act in good faith over some $23 million of payments to FMSS. It said they knew of the conflicts of interest and the risk of improper payments. It quoted the apex court decision, which described the process as a paradigm example of poor financial governance. The ministry noted that submissions on damages are to be made. It will continue to monitor the matter as public funds are involved. Sylvia Lim, Low Thia Khiang and Pritam Singh say they will be studying the Court of Appeal's judgment with their lawyers and will take advice on the steps ahead. Meanwhile, the coordinating chair for the People's Action Party's town council says the case calls into question the processes, structures and authorities in place to protect and serve residents. Lim Biao Chuan says Singaporeans have placed trust in their MPs. He adds that any misdeed means a breach in the people's trust for the entire political system. Looking forward, Mr. Lim is urging all town councils to continually examine their processes so that they can serve residents as best they can.
At least one analyst says that the Workers' Party is not out of the woods yet, saying that the case could go on for some time to come. Now, the ruling could set the stage for more lawsuits, for instance, on the damages that need to be paid. This adds complexity to the case and could affect their political futures.
I think if we cast our eye further, as to what's going to happen, after this case is completely resolved, there will be the issue of how the defendants, will pay for the damages that they're liable for, how quickly they can do so, and what's going to happen if they are unable, to pay for the damages. And when we're talking about the defendants who are sitting MPs, that could have an impact, on their parliamentary seats.